Our client became a Canadian permanent resident in 2017. He worked extremely hard to obtain his permanent residence. He successfully established himself in Canada. In 2019, he got married, and in 2020, he and his wife were blessed with a baby girl. His wife also became a permanent resident of Canada. The family was well settled, and life was progressing smoothly. In February 2022, an unfortunate incident occurred. The client was charged with impaired driving and driving with a child in the vehicle. Although it was never his intention to drive that day, circumstances led to the incident and he was arrested and charged. He retained legal counsel and made significant efforts to contest the charges. However, the Crown did not withdraw the matter. He ultimately entered a guilty plea to impaired driving. In February 2023, he was convicted and received a one-year probation order. This probation was completed in 2024. Following the conviction, he received communication from the Canada Border Services Agency. This communication was regarding potential inadmissibility to Canada due to serious criminality. We prepared and submitted detailed representations to CBSA. These outlined his strong establishment in Canada, his family ties, and the hardship he and his family would face if he were removed to India. We also highlighted his remorse and rehabilitation, and the fact that the offence was prosecuted summarily. CBSA reviewed the submissions and ultimately set aside the inadmissibility concerns, allowing him to continue residing in Canada as a permanent resident. The client enjoys travelling. After his conviction, he continued to travel internationally. Each time he returned to Canada, he was questioned. He was questioned about the conviction at the port of entry. However, he was always admitted to Canada without issue. The client believed he could not apply for Canadian citizenship until 4 years had passed from the date of conviction. He thought he would need to wait until February 2028. However, this was based on a misunderstanding. Impaired driving is a hybrid offence under Canadian criminal law. In his case, the Crown proceeded summarily. He was convicted of a summary offence. Since CBSA had already accepted his continued permanent resident status, he was eligible. He had completed his sentence and probation, and there were no ongoing charges or prohibitions. He was eligible to apply for citizenship. We submitted his citizenship application in January 2025. He subsequently completed biometrics, passed the citizenship knowledge test, and attended an interview. During the interview, the officer asked about any criminal history. He answered honestly and disclosed everything. After the interview, he received a procedural fairness letter